Good evening, everyone. Welcome to all to our event on the draft the European Commission's regulation of artificial intelligence systems. This panel is brought to you this evening by the UCL Centre for Ethics and Law. My name is Iris Chu. I'm director of the centre, and I'm very delighted and honoured to have my guests with me this evening. We have a fully packed panel this evening, and the panel will be led by Dr. Michael Veale of the UCL Faculty of Laws, who will give us his keynote address on his recent paper and his thoughts on the draft regulation. We will then be joined by a panel of three speakers, Dr. Ruben Binz, Professor Ronald Lanus, and Dr. Catalina Goenta, in that order. The order of proceedings will be that Michael will speak for about 20 minutes, followed by each panelist for about 10 to 15 minutes each, after which we'll take Q&A. So members of the audience, please feel free to submit your questions via the Q&A function, which I'll be moderating throughout this session. If we have too many questions, then I'll be selecting questions to be addressed to the relevant panelists during the Q&A session. And after the Q&A, we'll probably have a round of closing remarks by all of the panelists before we close. So let me now briefly introduce all of our speakers. Their full bios can be found on our event registration webpage. So I'll just say the essence of who they are that you'll be hearing from tonight. Dr. Michael Veale is Associate Professor of Law at the Faculty of Law's UCL. And he has published prolifically as well as extensively in the areas of digital technologies, internet and data law, technology policy, and the human-computer interaction interface. We then have Dr. Ruben Binz, Associate Professor of Human-Centered Computing at the University of Oxford, and he works between computer science, law, and philosophy. Following that, Professor Ronald Lanus will be addressing us. Ronald is director of the Tilburg Institute for Law, Technology and Society, and full professor in regulation by technology at the Tilburg Institute for Law. And he deals a lot at the moment with autonomous vehicles as well as regulatory failure in technology regulation. Finally, Dr. Catalina Goenta will address us. Catalina is currently Assistant Professor at the Faculty of Law at Maastricht University, and she's also a Transatlantic Technology Law Forum Fellow as of 2017. So without further ado, shall I now give the floor to Michael?
We're kind of getting into this stage in the policy process of the AI Act when a lot of people probably have seen an introduction to this act already somewhere. So it's a kind of awkward middle point. So I'm going to try and do a mix of introduction and a critique and discussion all in one and roll that together. It's like a maturity hype cycle of regulation. Everybody needs a few conferences or workshops to get their head around things. But equally, I don't want to leave people behind if they haven't heard about this already. So we will look at a bit about the structure. And the structure is now indicated by this like wizard hat / cone example idea here. And it's a bit of a related version of something the Commission tends to present when they think about the AI Act or regulation. Everything's an act now because it sounds sexier. The idea is a risk-based approach sees a staggered list from prohibition or authorization-based systems for unacceptable risks. Certain high-risk AI systems are meant to be regulated as in the product safety manner, according to basically the same regulatory scheme we use to put CE certificates on things. That's in Title 3. And then there's a kind of grab bag of interesting provisions at the end that deal with issues around transparency, Title 4. But the material scope of this regulation is actually much wider than just these separate little issues like prohibitions or certain kinds of products that are high risk. Indeed, we can see that because in Title 9, we have minimal risks, which covers just everything else can be subject to a broad certification regime, totally voluntary, and it covers all AI systems. And so what we can see here is an incredibly wide material scope of this instrument, where we see the AI systems are being regulated as an entire base, and on that, some little staggered regulation of systems of varying risk. And the scope of this is also in terms of the usual kind of verbs, the doing verbs of a scope, a material scope here. So AI systems are what's actually being regulated, but it's the placing on the market, putting into service, or the use of these systems. And we're going to come back to this use Because what we mean by the use of a system is much broader than what we mean by the marketing or the design of it, and can be construed in many ways. A typical issue with this kind of regulation around technology is how do you define the technology you're talking about? And AI systems are a buzzword. We've kind of seen, many people who are with us today will have sort of seen often with horror how the word AI has come to describe anything from an Excel spreadsheet upwards. And the Commission sort of follows this path in many ways, and it says that AI systems are effectively software developed using a certain set of techniques that are listed in the annex, and these are very wide. They go from logic or statistical approaches, and that effectively covers more or less anything you can do with a computer. It can be argued. And these systems generate outputs to meet certain human objectives, and they have to influence the environments they're interacting with. So they might not be things that we build upon, like Excel or Word. They might not be things that we effectively design on as a foundation because they're not generating outputs, but they could be a saved Excel spreadsheet inside that and anything up from that. So it's probably not all software, but it's a great deal of software, and it's a great deal of deployed software in any context, from public sector to enterprise to a variety of systems that will really be drawn into this. So AI system is about as wide as you can get without calling something software. So the material scope of this is huge. And why am I emphasizing this? Well, the material scope is a really important thing to pay attention to here, because the nature of this regime is designed to, in turn, reduce market barriers. The AI Act is adopted under TFEU 114. And this means it has to maximally harmonize areas that are within its scope, because the 114 is a residual power under the treaties where the Commission says we can see fragmentation, either current or potential in the future, in a certain area. So we're going to act to remove that fragmentation, regardless of what sector that fragmentation really affects or what area of law it really affects. So it's very different from other treaty bases that look at building on, say, public health or something like this. And they may empower the European Union to act in those areas, but in fact under 114 the Commission is empowered to act in many other areas, and also many other areas covered by existing parts of the treaty, if they can identify the potential for market barrier by turning it into an internal market problem. Never before has a product safety style regime, like the AI Act tries to do, has tried to harmonize the use of a thing. So this is what's quite interesting to begin with. Certainly 114 is being used to harmonize aspects of use. We see the data protection law was initially adopted on the equivalent of what is 114 today, although it has its own basis now. And that certainly is around processing, it's certainly around doing something in quite a broad and abstract sense. But never before have we really seen a product safety regime suddenly go beyond this to say we're regulating use. And the consequences of this is that most AI systems in this will be unregulated because there aren't specific regulations around the use of things that are not in those high risk or medium risk, or prohibited high risk or low risk categories. So I put up a list here of just some ideas of the kind of laws that could be preempted or challengeable by this wide material scope under the AI Act. These are things like consulting workers over AI systems in the workplace. You might think about quality standards for technologies that are designed to guess people's age on websites. You know, these are often trying to look at facial scanning. There are big markets for this. In the UK, it's often called safety tech. Say a government wanted to make not possible to sell these on the national market without quality standards. Well, that could be effectively foreclosed by the AI regulation. Requiring models to be trained in a climate-friendly way would also be a restriction on the design or marketing. Interoperability requirements for smart speakers, potentially, insofar as a smart speaker might itself be considered to be an AI system, then saying, well, the outputs of this system must conform to a certain kind of standard or schema could be preempted here. Use standards for translation systems that are used to translate people in the public sector. Procurement laws around just general purpose analysis for text that you might apply widely in a public sector organization, NLP technologies. And indeed, technologies laws that relate to uses of algorithms already in existing settings, like France already has several pieces of law that relate to algorithmic use in the public sector and requirements on design for these could be challenged too. Now, I'm not saying all these challenges would be successful. I'm just saying that these are the kinds of laws which is really not clear the AI Act would not be used as a weapon to try and strike down. So this dimension of the AI Act is really, you can't stress it enough, because only when we see the AI Act in this way do we understand what it will do to the European regulatory environment. So let's just have a look at one of the unacceptable risks. There's different categories, and you can see what I've written, I think, about it in the paper I wrote with Frederick Zoudeveen-Borgesius, called the Demystifying the Draft AI Act. But I just want to zoom in on one right now. Now, these are one of three: manipulation, which has got 2 provisions, social scoring, and law enforcement. And I want to just quickly look at manipulations. It gives you a little bit of an idea around why these prohibitions might not be all they're chalked up to be, and we maybe shouldn't take this part of the Act too seriously. So the manipulation prohibition effectively says that AI systems that deploy subliminal techniques beyond a person's consciousness or exploit vulnerabilities related to certain characteristics they might have, in order, so the intent is going on there, to materially distort a person's behavior in a manner that is likely, so an assessment here, to cause that person or another physical or psychological harm. The first thing to note here is this seems to be quite a high barrier for many reasons. Companies first have to sort of be shown to have some intention to materially distort behavior. And that's not just to influence or to lobby or to convince or to inform. It's actually a distortion. So working out what that looks like is quite a challenge. Has that be likely to cause that person or someone else physical or psychological harm? We know that many systems and many issues we talk about with AI are death by 1,000 cuts. They result from interaction with these systems in lots of ways, in lots of fora, in lots of scenes of your life. And that can lead to what Oscar Gandhi called in the early 90s cumulative disadvantage and rational discrimination. The idea is here that actually you might not be able to analyze a single instance, a sort of prototypical decision, and find harm behind it. And even beyond that, we start to see the limits on the technologies here, subliminal techniques. What is this? What have they declared? Well, at what point is something subliminal about as it relates to somebody's awareness of this happening? What if it's in their terms and conditions? And this exploitation of vulnerabilities, like this does sound like something that you might be worried about, because it might be about, say, scamming somebody with a system to try and get them to hand over their money if they might be elderly or infirm in various ways. And we see that with lots of scams over the phone, for example, already. But equally, we do have other laws that tackle this too. This wouldn't be a vacuum. And indeed, one of these laws that doesn't relate necessarily to fraud and just scamming elderly people, but relates more broadly, is Catalina's favorite law that I'm sure she'll be talking about. I'm not going to steal her thunder here. The Unfair Commercial Practices Directive. And that's got like a mixed and turbulent history as well in how it could really be used here. But frankly, the thing to realize here is that manipulation prohibition has huge amounts of text lifted from the Unfair Commercial Practices Directive. And so it's worthwhile thinking what this really adds. It conceptually adds some things, but because it adds new barriers like physical or psychological harm, new hurdles, we get to the point of wondering what this applies to. Luckily, our friends at the European Commission have helped us out. So the European Commission in presentations have indicated 2 issues that they think are going to be regulated by this prohibition. The first one is a crossover between Black Mirror and the Working Time Directive, an inaudible sound played in truck drivers' cabins that pushes them harder, faster, longer than healthy and safe, where AI magically finds this magical frequency of which there is no current scientific evidence that will cause people to go beyond the safe limits in the Working Time Directive. And so there's a magic sound going on here, and that's the kind of thing that maybe we should be regulating with manipulation, even though this subliminal technique seems to be quite an artificially constructed case. And in relation to age and vulnerable groups, the Commission also pointed out an example that looks a bit like the film Chucky in a way, a doll with integrated voice assistant, which encourages a minor to engage in progressively dangerous behavior in the guise of a fun or cool game. And this fun or cool game, this is a company that is selling a toy to try and get children to hurt each other. Firstly, I do think, and maybe Catalina could answer this in her session, that we probably have ways to deal with this under existing laws. And probably under the toy directive itself, you could probably argue this is not a good idea. But beyond this, we're fundamentally looking at something that these are quite absurd examples. And there is the other issues are similarly have holes in the prohibitions. So now to have a brief look at the high risk section. Oh, the high risk section is not there. That's not, here we go. I just, for some reason, it's skipping around. I have to go back to that slide in a bit. The high risk section says AI systems that are used or intended to be used in one of the sectors to the left. So largely public sector uses like migration, law enforcement, administration of justice, access to public services, but also essential private services, education, employment, and some private sector areas, namely employment and education, and some credit scoring. These, and if you're a utility company, maybe the management of infrastructure. But broadly, sort of public-private partnerships are tackled heavily here. And in these sectors, you've got different purposes. And the Commission could, according to their own draft, probably will get struck out, add more things to the services on the right. So these are intended services like intending to promote individuals or to sort their CVs or dispatch ambulances or to run as lie detectors, polygraphs, or to verify authenticity of travel documents, more polygraphs. And so like, we kind of on this and some assisting judges in interpreting cases and laws and facts. And also as components within other technologies that are currently regulated. So there are these quite closed lists of things that are high risk, and there's things that are not on this list which we might be able to think about. And the Commission picks up this structure called the New Legislative Framework. It's an approach about 40 years old now, not new at all. It used to be called the New Approach. The idea is the law defines essential requirements. These are things that are maybe quite high level, and they're written in the text. And because in the 70s and 80s, this took a long time, and Europe was trying to integrate much more faster than it was able to, it took a long time to get legislation passed, and by the time it did, it was out of date because the technical standards were written into the law. So the Commission created this way where they would just mandate completely bodies governed by private law, CEN and CENELEC, to elaborate upon these as harmonized standards. And these are produced and copyrighted by national standards authorities. You have to pay about £200-300 to get a copy of them. They're part of industry groups that draw them up. And then effectively, in the AI Act's case, you can mark conformity with these standards by virtue of self-assessment. Very occasionally, particularly for biometric systems, if that standard has not been adopted yet, you require a third party to check you're working. But usually it's just self-assessment. And then you can mark it with a CE mark, and it has to be able to move freely throughout the Union. These essential requirements, I'm not going to go into the details of them. I mean, maybe Ruben was going to sort of mention some of these things and discuss them a bit. But there are things like data quality, bias, accuracy, documentation, analyzing risk, and interestingly, designing for effective human oversight. So these are the obligations of the designers. Users of AI systems have very few obligations. They basically have to use it not off-label in accordance with the intended's purpose. So in a way, there's an obligation for providers to do this certification right, and whether they did it right or wrong, only the obligations that the providers manage to get right flow to the users. So the user has to complete human oversight, for example, according to instructions, at least according to instructions, left by the provider. And if the provider self-certified and didn't provide very good instructions, or didn't really assess this properly, or was very loose or lax, the user has very few obligations. This is a non-personal user, so largely a commercial user or a public body. And standardization here will matter hugely. These standards bodies, CEN and CENELEC, these are the European umbrella organizations for national standards bodies, like in the UK, BSI, for those of you who are in the UK here. And BSI is still a member of CEN and CENELEC, so will have a say in this, regardless of Brexit, interestingly, and several other non-European countries do. These draw up, effectively, very value-laden standards that have to touch upon fairness, accountability, oversight. These are not the standardization of plugs anymore. This is not the safety of PPE and its ability to let through gas. These are issues touching upon all areas of the Charter, or a very, very large number of them. As the recitals indicate in the AI Act, they list about 10 or 12 Charter articles, including good administration, which I don't think CEN and CENELEC are very well placed to talk about. And the right to a remedy, which is hardly something that a standardization body is really going to be good at knowing about. These are industry heavy, labor intensive to make, and only organizations that have really had a strong history of standardization can do this. So So I'm not going to talk about the transparency obligations. We can talk about those a bit. Suffice to say that these obligations, which are on bot declaration, deep fakes, and emotional AI, range from not applying to almost anything at all that makes any sense. The scope seems to be completely wacky and out, or overlaps with existing law. And so I think this will be a big ripe area for reform and revising of this law in Title IV, because at the moment, this strange grab bag of horizontal transparency obligations for deepfakes, bots, and emotional AI are bizarrely written, to say the least, and not very full of holes, typically. So lastly, I want to just highlight some cross-cutting issues. No rights for affected individuals here, so enforceability is going to be limited. This is the case because the product safety regime about relations between providers and those who buy it, who are one step up from people who are affected by it. High-risk systems, like I mentioned, public-private partnerships. The enforcement body, a market surveillance authority, is not guaranteed to be independent. So they have to go against what is possibly a monopsony vendor of, they're going into a monopsony where there is effectively one buyer, the border agency. And if they're going to say this border control system is illegal, they are going up against their interior ministry. And that is not something that a non-independent body can do effectively, especially one, as the Commission estimates, that will have between 1 and 25 additional hires per member state. Tiny, low capacity. How are they even going to take legal cases in this regard? DPAs, even the beleaguered Irish DPA, has hundreds of employees, data protection authorities. There's going to be a structural skew of getting any clarity on this law because there are very few routes to preliminary references. A preliminary reference is largely going to be made, I would estimate, by either an appeal from a market surveillance authority, because there's no sort of private right of action in this law, where a market surveillance authority, which is tiny, takes an enforcement case, which is then appealed, then you might get a preliminary reference. You're going to get lots of strategic litigation by technology companies and similar to try and say the AI Act is going to preempt national law. So that's going to give you preliminary references, but that's going to be about, can this national law be struck down or not? So it's not going to be providing so much clarity on the terms inside the AI Act. And you're going to get maybe some, if you subject some of the user requirements of public authorities to judicial review. So you might have some routes there that could generate some preliminary rulings, but you're not going to have. You're going to get the structural skew where the people bringing cases are largely going to be those who are high-resourced organizations who want to bend the law in their favor, not individuals who wish to use these as consumer shields. And this lack of clarity in the law, because of that, is going to be abused. You are going to get companies that will not obey this law because it has not been clarified. Facebook do this regularly. They pick on any gray area and just ride it out as a license to operate until someone fully hashes out. They will not accept the Aclair doctrine. They will try to go the CJU again if it gives them more time. So in sum, horizontal prohibitions and transparency obligations, they sound impressive, but they fall apart under scrutiny. Product safety is a limited regime. Organizations that now need to go beyond their expertise, remit, legitimacy. This is going to be used to strike down national laws because of the way that 114 works, and the EU adopts almost all digital regulation on 114 because there's no digital treaty base for digital regulation. So there's not a great other option. But equally, we have to bear in mind that there are limits to the internal market frame when we're regulating fundamental rights or trying to. And market surveillance authorities have never governed use before. I mean, they're being asked, if they are regulating deepfakes online, this organization to regulate the entire internet. Bizarre choice. And this is a bizarre choice of enforcement body for AI systems, I think, in general. So with that, I'm going to pass over to my wonderful co-panelists and see what their own areas of expertise hopefully bring to this area. Well, they're definitely going to bring lots of things exciting. So thanks, everyone.
Thank you, Michael, for your very critical and scintillating discussion. Without further ado, I'll pass over to Ruben, who will give us a perspective with his expertise on feasibility as well as risk management. I think we already have a question on feasibility and hope that Ruben will certainly enlighten us in this area.
Thanks. Can you all hear me all right? Great. Okay. So yeah, I'll try and cover a few things. First, I'll make a couple of small comments on definitions and scope. And then Iris asked me to focus on some of the essential requirements. So I'll try and go through some of those. And then finally, I'll discuss what I think is one of the aims of this regulation, which I'm skeptical about whether it will deliver on, which is the idea of trying to responsibilize the AI supply chain. So first point about definitions. I think Michael covered this already, but the definition of AI systems is very broad. It includes machine learning, includes symbolic approaches to AI, which is the more old-fashioned approach, includes basically statistical models in general, anything that takes some human objectives to generate outputs to affect an environment. I don't think it's a bad definition of AI, all told, but it is very broad. So that's the first thing to know. This does cover a huge range of things. More specifically, some of the definitions of particular systems are also quite strange or potentially flawed. So, for instance, the definition of biometric systems suggests that they could be used to assign people to categories using biometric data, but also things like political affiliation, gender, sexual orientation. Now, sort of definitionally, these might be okay kind of examples, but it's very dangerous to put these examples into definitions because these technologies are fundamentally flawed. So even within some of the definitions, there's some quite worrying inclusions of examples of technologies which just don't work in practice and are very harmful. And then finally, just a point on the sort of the definition of bots and deep fakes. So I still don't understand how these things are going to be defined. So for Article 52.3, there's obligation to disclose when you are deploying a bot that's going to be interacting with people. And in theory, this is a good idea because I don't think people should have to go around online interacting with things that might be people or might be bots and having to do their own like Turing tests to figure out if they're talking to a real person or not. But it's actually, I think, quite difficult to define a bot because there are many things that exist now, like if you've ever had your phone suggest to you a range of automated responses that you could type in response to someone who's emailed you or asked you a question. Is that a bot? You haven't typed the sentence yourself. It's just been suggested to you, a whole email or a whole text message suggested to you. Is that a bot or not? I'm not sure. Okay, so some definitional issues there. Moving on to the essential requirements. So this is Title 3, Chapter 2. These are the requirements that will inform what would be required under the prior conformity assessment for high-risk systems. So providers, in theory, would have to go through these prior conformity assessments before placing their systems on the market. And the conformity assessment would allow them to place a CE mark on the AI systems that they're selling so that they can be put on the market. Now, a big caveat here, as I understand it, the argument that Michael and others are presenting is that in practice, we can almost forget about these requirements because they will ultimately be converted into a different set of requirements by the standardization bodies, CEN and CENELEX. So in theory, they exist, but in practice, they may not actually end up looking quite like what we've got in the regulation. But let's just imagine that they are. And then the question is, what we have in there, is that a good starting point? So what's in these essential requirements? So they're quite heavy on risk management systems. So documenting and managing risks across the AI lifecycle. So to document and manage risks, you need to have foresight of what those risks might be. And so the providers need to be thinking about how risks will arise when people put their systems into use, when they are used as intended by the provider. And those risks need to be mitigated and brought down to an acceptable residual level through various forms of mitigation. So this is common practice already in many organizations, and so this would kind of, in theory, could solidify these existing risk management practices. Now, my sort of general opinion of risk management outside of necessarily the specific AI context is that it's a quasi-quantitative way of combining what are largely quantitative judgments of risk and probability that human managers will be coming up with. And while they're useful in many ways in terms of articulating, trying to foresee risks. They do often provide a sort of sheen of statistical rigor that often isn't there in practice. But when we come to AI systems in particular, I'm really even more skeptical, because the risks of these systems are often emergent, they're ongoing, they're changing, but importantly, they're distributed between different parts of the supply chain. So risk management wants to simplify the world, make it quantifiable, knowable ahead of time. But when it comes to AI, these things are really distributed. The knowledge to anticipate these risks is distributed between the different steps of the AI supply chain. Worth also noting that many of these things are potentially already required under GDPR, things like Article 35, impact assessments, and in many cases, these are already standard practice. Article 10 focuses a lot on data and data governance, and there's some good stuff in here, things like data sets needing to be subject to data governance and management, things like formulation of assumptions about the information and data that is used to train models, to measure how good they are, to consider where there might be data gaps and shortcomings. These are all good things that we should be wanting AI systems to have around them. One thing that has drawn attention in this context is the Article 10.3, which requires data sets to be relevant, representative, free of errors, and complete. And I think some people have said this is unrealistic, which is true. But the requirement is defined a bit more reasonably in Recital 44, which says that they just need to be sufficiently relevant, representative, and free of errors. So I think that's a more reasonable requirement. Article 10.3 also requires data sets with appropriate statistical properties, which is kind of weird because in machine learning, as an example, we typically don't know when the data has appropriate statistical properties. We have to hope that it does, and the data is never going to be perfect, but we can minimize errors when we see them. There is a lot in here about data sets, which makes sense in terms of the current focus on machine learning as the dominant form of AI. But given that the regulation wants to encompass a huge different range of AI systems, the focus on data sets that are used in machine learning specifically does make me feel like there's got to be some missing aspects for other types of AI that you would want to have in place that aren't specific to the data sets that you use. So the whole thing is quite ML centric when you look at the essential requirements. There is a bit in Article 10.6 which just says if you're not using ML, then you also need to apply appropriate data governance and management, but it doesn't really explain what that would look like. The stuff around exemptions to process protected characteristics for discrimination analysis, which is, in theory, could be a good thing for AI providers to do this kind of analysis, but it's only available, this exemption is only available to the provider. And this is problematic because in practice, it's often going to be necessary for the users who are implementing the systems in particular context to undertake their own discrimination analysis. So in data protection terms, it's very likely that it's the user who would be a controller who would have to also at least participate in the fairness analysis, probably as a joint controller with the provider. So I think that exemption is probably limited in many ways. Articles 11, 12, 13 include things like documentation, record keeping, transparency. I think they're broadly positive things and they support emerging sort of best practice in the world of machine learning. So things like data sheets for data sets, which describe where data comes from, where it might have blind spots, where there might be ethical issues with the data, and model cards, similarly, those kinds of questions for models. These are kinds of best practices which I think would be supported by Articles 11 to 13. So those are broadly positive. Article 14 talks about human oversight provisions, which I think, again, largely positive. However, I would say there are issues here around whether human oversight can be identified and built into systems by providers, because it's the users that will actually, in practice, be providing the staff, the human decision makers who will be overseeing these systems in practice. So there's potentially, again, a mismatch between the context of use and the upstream provider trying to anticipate that context of use, because, yeah, as I said, the user, the organization that's deploying the system will be the one that's providing the human oversight in practice. Article 15 talks about accuracy, robustness, and cybersecurity. I think these things, again, important, but there's probably a lack of detail here. And many of these things are dependent on context. And again, the context is something that often only the user will know, and only the user can measure and secure in context. So things like security problems, these typically emerge when you knit together systems in practice. And so trying to solve security of an ML or an AI model at the point of provision to the market is perhaps unrealistic. Sort of moving on, I mean, one question I still have is, where do AI systems bear the CE mark? It's not like a plastic toy that you can put a sticker on. It's an API. It's a model that you sort of deploy in production. I'm still not sure how that works, but hopefully that's something that's a practical point that can be overcome. But my overwhelming takeaway from this chapter, I think, is the tension between the desire to have generic risk management regimes for AI systems as they're deployed on the market, and wanting to have providers manage risks that arise from them in specific contexts of deployment. I think it's really difficult to imagine that a provider would be able to get granular enough about the context of use to actually manage those risks. You can either aim for kind of generic risk management for everyone, or you can look to make AI systems kind of safe, trustworthy in specific contexts. But you can't expect the providers to be able to anticipate all of those things. How long do I have left? If I shot over my 4 minutes. Okay, so just quickly on this point, one of the things that I was really hoping that this regulation would achieve was responsibilizing the AI supply chain. And this is important, I think, because there is a slight gap in data protection law where providers of AI systems are responsibilizing the users because they are wanting to pose as data processors and not controllers, which means that the user of the AI system would be the data controller, but they wouldn't necessarily have the power or the technical capacity to modify the system in ways that would make it data protection compliant in their own context. So my hope at the beginning of this AI regulation was that it would apply some measures of responsibility to the providers who may not be controllers, such that they no longer put controllers in this difficult position of not being able to actually meaningfully comply in context. I don't think it actually achieves that purpose, unfortunately, because I think the way it's structured is at odds with the reality of the AI supply chain. There are lots of different ways that actors can be involved in providing AI, and there are lots of grey areas between provision and use. So, for instance, a researcher might make an ML model, put the code and data on the web for anyone to use. That model could be used for a high-risk use. It could be used for low-risk use. From the researcher's perspective, they might not mean to place it on the market. They might just want to share their code and data openly. Then, say, an ML engineer at a company copies that model, builds it into a machine learning as a service. Then that gets used by another company to provide a piece of software that has AI within it as a widget. This is all these different things can be broken down in even more fine-grained ways. But to me, we don't see enough of an acknowledgement in the regulation about these complex sorts of supply chains. We do see some acknowledgement somewhere, like recital 60 talks about third parties that are up the supply chain needing to cooperate with providers and users. But this, I think, just opens up a minefield of other questions. I just don't think it's realistic that providers will be able to, or will have sufficient incentive to do the kind of post-market monitoring of uses by downstream users to actually meaningfully protect individuals and groups as these systems are deployed in practice. So just briefly to summarize, I think the approach that I was hoping that we'd see would be that this regulation would, to a certain extent, responsibilize providers, such that there's not this kind of puppet controllership system that we see with data protection, and so that we'd have providers and users being jointly responsible for at least some of the risk management processes, whilst keeping some separation of responsibility. I don't think this regulation is going to get us there. ML is not a product that you put on a market. It's an imperfect imprint of historical decisions by human decision makers that encode biases, that encode value-laden questions, and taking them from the context that the training data is from and sort of regurgitating them in multiple different contexts, which are hard to specify in advance the risks that might arise. So that's a whistle-stop tour of some of my perspectives on the technical feasibility of this regulation. Thank you.
Thank you, Ruben. I like the critique very much. I mean, my impression of reading the AI Act has given me, a lot of impressions with regard to whether or not some of these risk management processes are feasible, whether what is asked for compliance is too much. And I work largely from the point of view of compliance and regulatory policy. And so I'll be interested to see how this shapes up. So moving on to Ronald, the floor is yours, Ronald.
So we've had a number of critical voices already of the Act, and I won't dive into to the Act itself, but try to take a sort of a step back. And Iris said that I'm interested in regulatory failure. Well, maybe this is it. So we're in this weird world of AI where we're told that AI delivers all sorts of wonders. So we're told that facial recognition allows systems to recognize and identify people on images, and AI certainly has made big strides in this domain. But a few steps further down the line, and we can no longer enter stores and access public places anonymously. We're told that Google is very smart at guessing what we're looking for, and indeed it is, scaringly so. I find this the most intimidating piece of AI that I know. But with that, it also propagates the most awful stereotypes. We're told that self-driving vehicles will take us everywhere without having to worry about steering the car. The AI in the car will take us anywhere on these empty roads. But what about the urban jungle? At one point, I think the car will have to decide whether to hit Super Fido or stock photo guy who appears out of nowhere, or crash our car into a lamppost. We're told that our children no longer have to go to the battlefields because autonomous weapon systems or killer drones can and will do the killing for us. But that may gamify warfare to the point of indifference about human life, and I don't think that that is a good idea. So do we want all of this? No, well, I don't think so. And generally, I think that there is hardly anyone left on the planet that thinks that AI should be left totally unregulated. So what to do? Well, given that I'm a bit of a regulation scholar, I would say regulate, as in control. We have to set boundaries for AI development and use. Now, of course, I wasn't born yesterday. I mean, you can see my gray hair, etc. So I do understand that we're told a lot, also in AI land. Not all AI promises are met, not all positive and negative effects materialize. But still, serious issues are and will be materializing. So what to do? Well, that is not entirely straightforward. I mean, we have this AI Act on the table, but AI is a disruptive technology on many accounts. So we don't know what it is exactly, how it will develop. The only thing is we know by the hypes created is that it will change everything. Relations, work, society, life, everything will change, right? So we're facing an unknown future, both in positive and negative senses. Now, if, of course, you have this Collingridge dilemma thing here and also the pacing problem and what have you. So typically when we're facing an unknown future, we have to we need to carefully balance interests. And this is why sometimes there's this call for ethics frameworks to the rescue. So resort back to abstract principles that provide flexibility and room for actions appropriate to the context. Leave it up to the developers to interpret the abstract norms and let them come up with the best behavior. Now, this was the early days, right? So we've seen these frameworks around in Europe, in China, in the US, India, everywhere. Now, the trouble with these frameworks, of course, is that they're mostly non-binding and thus hardly enforceable, and they may lead to ethics whitewashing, etc. So the problems of that approach are relatively well understood. And fortunately, and I'm glad for that the Commission has taken a bold step in any case, is to say, well, these frameworks are nice, but we need more. We need to take careful but bolder steps. And this is where the law comes in. With all its subtlety, hard law, soft law, self-regulation, certification, whatever, everything will be put on the table to try and regulate this AI thing. And law may incorporate sanctions, which makes it harder than ethics, right? That may get people in line. If there are fines, then that may have effects. If you lock up people, that will certainly have effects, at least we think so. Of course, this is also a reason why the industry isn't too fond of law and regulation, because there may be serious consequences of misbehavior. Now, resorting to law is an approach that we certainly need in this realm, but it's not the full answer, because the law itself may also become disrupted by AI. And so I've built this graph based on a paper in Law Innovation Technology that I find interesting. Now, in some cases, problems simply aren't real problems, right? At least from a legal perspective. Many parts of the law are totally agnostic to technology, and existing rules may thus well apply to AI as well. This is not an AI example, of course, but it doesn't really matter whether you try to kill Wendy Torrance by axe, by owl kitty, or by poison. It is still murder or manslaughter or whatever it is called in your particular jurisdiction. And so it may not matter how you decide questions by using a flow chart, an Excel sheet, a neural network, or a simple formula. If there are clear rules, I'd say bring out the whip. So in some cases, existing law is fine. Now, sometimes the simple legal answers are unsatisfactory, but maybe a simple fix may bring the topic back in known territory. We see this all over history, all over the place, right? Windsurfers, segways presented problems in the past because they didn't really fit the existing categories of ships, vessels, mopeds, pedestrians, what have you. Resolving that is fairly simple. You decide where you want to go to have these things go. Segways either go on the road or on the pavement, and you classify them according to other things that are on road or pavement. So this is what I've labeled easy regulation in this diagram, a simple fix to a couple of provisions in existing law. Now, sometimes the issues are bigger and we need more constructive or reconstructive work. And here we enter the red pill. So we know, for instance, that the classical distinction in law between objects and agents is potentially breaking down or is breaking down because of AI taking a sort of a middle ground. And this may require significant legal overhaul, but that's for another occasion. With the proposal of the AI Act on the table, we've entered what I've labeled harder regulation here, meaning it's more significant than a simple change to a single rule, but it's less than major overhaul. And we have 107 pages of text, 85 provisions, 70 pages of very relevant annexes, etc. I mean, that is a significant beast, and it's all over the place. Now, everybody in the audience will have sniffed or taken a deep dive in the Act, so I won't go into the details here. I want to say something about whether I think the approach in itself of having an AI Act is the appropriate one. But before doing so, I think it's important to zoom out a little bit. And I'll bring some stuff to the table that wasn't mentioned by Michael and Ruben yet. So what I think is important in the regulation is that it sends some clear signals to the world, right? One is playtime is over. If you want to use the term AI as a marketing tool, then think again. There are or there will be rules that you may be bound to that make it less than obvious to use the term AI for stuff that isn't. Problem, of course, is, as Michael explained, that almost Excel sheets also fit within the category of AI. So that might be problematic there. The second thing is that, and that's equally important, I think the political message that the EU sends here with the AI Act is important. We want to make sure that AI systems that are developed and deployed treat us as humans. I mean, totally in line with the European Fundamental Rights Framework, etc. And we've seen the same thing with the GDPR. The GDPR is cumbersome, extensive, and in search of a favorite adjective here, set of rules, but it is also a message that individuals' data should be handled carefully. And that message is being adopted across the world. So, and maybe the AI Act will have the same thing. So it incentivizes people that we have to treat people seriously. And much of the AI Act is trying to prevent from being succumbed to computers that simply say no. So that's where the transparency things are, etc. Part of that, at least. And if we leave things to be handled by AIs, and Ruben pointed that out, then only if we're damn sure that they're reliable and robust, hence the documentation, hence the representativeness, and what have you. Now, elsewhere you can find some diagrams I made of the Act, and here is the sort of the high-level overview that suits my purpose. So the regulation, primarily deals with high-risk AI systems, and Michael showed us the hat. Here's the types of systems that are distinguished in the Act. But that for the rest of my talk, that really doesn't matter. Because the question is AI system the right target? And I think here great minds diverge. Every time a new technology enters the stage, we hear this call for a new law, statute, act, what have you. And I think this knee-jerk regulatory response to the flawed law syndrome, we need something new, is also at play here. There's a tendency to create particular technology-centric regulation or treat some phenomenon as unique, require a specific body of law. But sometimes it makes sense to create a set of rules. Sometimes it makes sense to create a set of rules for specific things. Certainly when that causes specific risks. But what is the case here? And I think Philip Bryce 8 helps to dissect the thing a little bit. 8 distinguishes 3 layers at which we can talk about technology. Technology, artifacts, and applications, right? So and technology is, for instance, nuclear technology, and each of these layers has specific ethical and regulatory questions. So with nuclear energy, atom bombs are a thing on the higher level. Then you have artifacts, which are specific sort of uses of things. Nuclear reactions, X-ray smoke, so nuclear waste is there a concrete example. And then applications is a specific instance in a specific context. So X-rays in airport security, where privacy infringements may be the issue. Now, here's the application of that framework to AI in general. So AI, a generic issue for all AI may be that it affects autonomy. Then on the artifact level, we have facial recognition as a type of AI thing, and their bias might be an instance. And on the application layer, we have billboards in train stations where loss of autonomy or something or whatever might be the issue. Now, the thing is, where does the AI Act fit? I think it is all over the place. There is no clear target in this framework, and that may not be a good idea. So what to regulate then? And this is sort of not well thought out, but usually we aim at specific things. Like in some cases we regulate means, like infrastructure. It makes sense to regulate, let's say, railroads or something, and because that has specific things. In other cases, we regulate a certain practice, so data processing, that's where the GDPR fits. It may be that we regulate or try to prevent certain effects. Non-discrimination regulation is case in point there. It doesn't have a specific target. It simply says, whatever you do, don't discriminate. And sometimes we focus more on risks, and that is where the precautionary principle typically comes into play, for instance. That would make more sense, I think, than to try and get everything under this AI systems approach. Feature either on specific applications and not so much on the artifact level, or try to frame particular risks that you want to prevent, but then abstract from the technology. So applications matter. So it's not, so facial recognition was on the artifact level. It's not so problematic in the context of my photo app that helps me tag my images, right? It only affects me. More problematic in this case is that my photos doesn't recognize me. Okay, but the fact that the technology is crappy is not so important, nor that it personifies English houses. I mean, I can live with that. What is more problematic is apps such as name tag that allow identifying people on the street by anyone with a smartphone, or the use of clear view AI by police forces, or worse, billboards that recognize you wherever. But actually, I don't care whether it's an AI doing all of this or an army of people, right? So the Stasi was also facial recognizing people through cameras. That's equally disturbing as an AI doing it. The loss of autonomy or the loss of anonymity is the problem. And we should focus on those risks or those harms, in my view. So the expression is not seeing the forest for the trees to signal that somebody focuses too much on the details. And my message would be carefully pick the right level to study and provide solutions for problems. If I have a little time left, then I want to field, I have 2 slides, a couple of observations that may enter the discussion later on. So I think the message of the AI Act is good. So playtime is over, take rights seriously, and it allows to cut the wheat from the chaff. So everything's labeled as AI, just as everything was labeled as nanotechnology 15 years ago, right? Crap, if it's not AI, then stay away from this. I think the base requirements for data-driven stuff is good. So the quality measures, the accountability part of the transparency is also fine. But the thing is, without enforcement, and how can you enforce this thing because it's all over the place and very fuzzy, this is not going to work. And GDPR enforcement at the moment doesn't make me very optimistic on AI Act enforcement, which will, as Michael pointed out, will be even more problematic. And I think that actually the risk-based approach, as promoted by the Act, is an empty shell. There is no risk-based things. It's prior sort of risk-based risk assessment of entire categories of things which are empty shells. Again, Michael talked a bit about the 8 types in the annex. I mean, this is just labels. Okay. Oops. Hang on. Where are we? Yeah. It is not clear what the target is, so you get a fuzzy set of norms because it tries to do too many things. Some people think that the AI Act is about automated decision making. I think it's not. That's only part of what is covered by the Act. I mean, trains, medical devices. I mean, there's the whole range of things mentioned at the beginning of the Act that most people forget about. And I think it's very important that those are handled, but they're also already handled in other regulations. Why does the AI part actually matter? Does it really make a difference whether you throw dice or AI? Why? I mean, it's about the outcomes of processes that affect human beings that we should worry about, not what kind of particular technology is used. Now, if it's risk-based, which might be a good idea, why not generalize the whole thing? I mean, get all the dice, the neural network, flowcharts, everything. It's about the decisions that we should care and not about the particular technology. Yeah, okay. We now have the GDPR, we have the AI Act, we have the DSM, DSA, the Data Act. How many more of these things are we going to get? It's becoming an incredible forest. So normally I like to end with harmony restored, but in this case, I have more questions than answers. So thank you very much.
Thank you, Ronald, for this whirlwind tour of.
And sorry for being a bit over time.
Oh no, don't worry about it. I think we've really benefited a lot from this high-level overview, and I share a lot of the concerns as well. Without further ado, shall I pass to Catalina?
Thank you very much. And first of all, thank you for the invitation to this absolutely amazing event. It's already been incredibly fascinating to listen to all the panelists speak. Michael, wonderful paper. It was really a pleasure reading it. And especially because what you were mentioning at the very beginning, the tapping into basically consumer protection. And this is what I would like to focus my contribution on. 2 points. So first, from the perspective of Article 5, which lo and behold, actually is very similar to the Article 5 in the Unfair Commercial Practices Directive. And I also noticed that we have a lot of guests who are very well versed in consumer protection. And I'm very curious to also hear maybe their questions in the Q&A phase of this panel. So the first point is going to be about Article 5 of the AI Act. And then the second point is going to be a more general comment about the market surveillance authorities and their role in the enforcement of the AI Act, or at least the way in which we are supposed to consider that at this moment in time. Perhaps a disclaimer is going to be on my side, the fact that I haven't really set out to criticize or to maybe support the AI Act, because I think that its complexity is overwhelming, as Michael was mentioning at the very beginning. I really liked what Ruben was mentioning. Still not sure how that works. I'm willing to maybe, I don't know, launch a challenge and see how many years from now will we be able to still say the same thing. I'm not sure how that works, because especially when it comes to the UCPD, and allow me to immediately delve into the 2 Article 5s, 14 years later, there are still aspects that we wonder how exactly they work. So Michael, you showed this wonderful slide about Article 5 of the AI Act, and Article 5 with this very convoluted set of tests. So Ronald, you were also mentioning the prohibitions of basically the prohibited practices that are supposed to be completely not available on the market. So this, of course, really reminds us of the UCPD. We see a lot of the similar language. So in the paper, I think Michael and Frederick were mentioning also how the UCPD is looking not only at contracts, but also basically pre-contractual and post-contractual situations, advertising. And this is also what the AI Act is doing as well, with the idea of placing on the market, putting into service, or use. So really covering a very wide range of activities around the deployment of AI systems. Now, what I'm kind of puzzled about, and I really hope, and I'm sure, but I hope that I'm not the only one who is puzzled about that, is basically the very wide array of open-ended concepts that Article 5, and I'm just looking particularly at Article 5.1a, that basically are mentioned within the scope of the same type of test. So Michael, you mentioned already the subliminal techniques. I'm just genuinely curious how the legal interpretation of a person's consciousness is going to look like. That puzzles me quite a lot. I can immediately notice that there's a difference between the AI Act Article 5 and the UCPD Article 5 with the material distortion of a person's behavior, because the UCPD mentions the economic behavior of a consumer. And then obviously, and perhaps understandably so, we have this causal link that needs to lead to a specific type of harm. In the UCPD, we're speaking about a transaction that can be perceived as harmful. And in the AI Act, we're looking at the physical or psychological harm. Furthermore, for instance, in paragraph 1b of Article 5, we look at the different vulnerable categories of users, and we see the typical categories of vulnerability, so age, physical or mental disability, and we see that perhaps they should be looked at in particular with respect to the type of protection that needs to lead to this test of prohibited practices being met. What I don't see, again, is also, for instance, the standard standard outside of the vulnerability categories that were just mentioned, a standard like the average consumer test. So in the UCPD, there is this benchmark against an average consumer, what exactly would change the behavior of an average consumer. And already, even with this test, where so far, and especially in the preamble of the directive, it is mentioned that this test is a normative test, so it's not a statistical test, which has led to the situation where national courts around the European ecosystem have been interpreting this in very different ways. Basically, a judge needs to simply think, what do I think is the average person? And then we have perhaps different outcomes. Even that standard, as general as it may be, creates this concept, which we have seen and which at least I am familiar with from the way in which private law operates, especially on the continent, from the perspective of codification. So we see that there are these kind of standardized categories of users, and the average consumer is one such category. Now, if I look at Article 5.1a, and I'm just very curious also what the rest of the panelists have to say about this, or if they have thought about this. Basically, if we're speaking about the test in 5.1a and that would establish the prohibition of artificial intelligence practices, then who are we talking about? Are we talking about an individual? How are we going to apply this particular test in individual cases? And to what type of diversity is that going to lead from the perspective of legal certainty? That is a question that I would like to perhaps ask and see where we can get with that. So basically, in general, I think the Article 5 of the AI Act has very clear roots in unfair commercial practice law. It is interesting that this has been a choice of the European legislator. The Unfair Commercial Practices Directive has been very useful in terms of covering a very wide array of harms that we see right now in the digital economy. And the main problem with it has been, as much of a fan as I am of this instrument, the main problem has been legal certainty and interpretation. And with courts lagging behind in interpreting and creating this legal certainty, that comes with a kind of a blanket test that we need to contextualize. It has led to a lot of problems in the market, where maybe the kind of practices that Ronald was mentioning, the game time is done. Everybody needs to be aware that, if you're going to label a product as AI, you need to be aware of these rules. I argue that perhaps with the emerging legal uncertainty, with the interpretation, the potential interpretations of these particular articles, perhaps this game time is not done yet. And we see this with a lot of companies just pushing the boundaries of commercial practices that you could argue would fulfill the test in the UCPD Article 5, but without or absent any kind of judicial assessment of that, absent any kind of, maybe regulatory enforcement guideline from an authority that deals with competition or consumer protection, then it's completely up in the air. So the legal uncertainty is basically where maybe disruptive business models have been hiding in the past and have been creating new forms of harm, because it has been just very unclear whether it is possible to cover the existing practices with existing rules. So this was the first point that I wanted to make. The second point deals with the enforcement, and Michael is mentioning in the paper together with Frederick that basically the enforcement is expected to take place by market surveillance authorities. So at least unlike the DSA, there's not going to be maybe additional authorities, but who knows? Let's wait and see what will happen. But you also mentioned the Toy Safety Directive and the example with the Chucky toy. So of course I had to go to the Toy Safety Directive while you were mentioning that. And I mean, for those of you who really want to perhaps better understand negative feelings towards European law, you can check Annex 2 of the Toy Safety Directive. And that is because, and that's good and that's bad. So that is because on the one hand, if you look at this annex, you are going to see like a list of very clearly established risks that market surveillance authorities need to be aware of, need to be very clear on, and need to basically just be attentive to remove from the market. I mean, you have limits on the amount of barium and zinc in toys. There are specific numerical limits on that. There are basically lists of allergenic fragrances that are not supposed to be in toys, that are not supposed to be included in toys. There are lists of physical and mechanical properties, chemical properties, radioactive properties, electric properties that toys need to comply with. And this is where the standardization comes into play. And this is where product safety law, or this is what product safety law has established on the internal market, this idea that if we're supposed to develop the internal market, and that's a good thing, we should have some sort of standardized ways to say what is safe in every single member state. However, this has also led to basically a very technical list of requirements that, for better or worse, actually authorities know how to deal with. So you have these numerical measures. Okay, if they're there, then it's fine. If they're not there, then we need to remove the product from the market. I would definitely encourage all of you to maybe for some anecdotal experiences to have a look at the SafetyGate European Commission database, so you can see the kind of products, the kind of toys in particular that do not meet the requirements of such a directive, and to see also the very specific headlines on which they do not meet these requirements. So now going back to the AI Act, I'm just wondering also on the basis of what Ruben was mentioning, on the basis of these risks that we're supposed to understand from the deployment of AI systems, how can we use product liability law in such a way that can inspire a field where these risks are in no way anywhere close to being broken down so specifically as we have seen basically the harmonization of product safety rules happen in the past. And I think that this is going to lead to even more legal uncertainty when it comes to the enforcement of the AI Act. I think that it is highly important, and I don't remember exactly who mentioned this before, but I think in Michael's presentation, this was the case, you know, the tiny amount of resources that are going to be available also for the enforcement. I mean, how exactly are all of these clarifications going to happen in an environment where maybe digital literacy needs to be much higher in order to really understand even how to create some sort of basic classification. I trust and I definitely see the potential of cooperation networks like the CPC network on the level of consumer protection. There's also new powers of investigation and new powers of enforcement that have been given through the CPC regulation, I think 2 years ago. But the question is, how will all of these authorities deal with these powers, and how are they going to exercise them in a way that can be basically transparent, but also lead to some degree of legal certainty? And then within this context, I think I found what Ronald was mentioning with the idea of focusing on the application very interesting. But I'm genuinely puzzled as to how the guidelines are going to look like, how the guidance for enforcement authorities will look like in terms of what exactly is expected from the enforcers in terms of removing these types of products from the market. So I will leave it to this. I look forward to the questions and the discussions, but I think generally speaking, I see the problems that have been raised by all of the speakers. I'm just really very generally at a loss for solutions, because I think that first and foremost, we need to better understand what exactly the AI Act aims to shape in terms of expectations for enforcement, at least in one sense. Thank you.
Thank you very much, Catalina. I think we do have one question right at the top of the Q&A, which echoes my own sort of question that I would like to address to both Ronald and Catalina. I mean, I'm under the impression that in terms of technology, I think the regulation seems to be over-inclusive. Then in terms of risk, it seems to be under-inclusive. And as the question is asking, you know, some of the risks that we are desperately trying to regulate with the high-risk systems, they are done, you know, in other types of contexts, especially in online, you know, advertising, online commercial practice. I just wondered to the both of you whether you think the UCPD is already sufficient, or are we looking at a more comprehensive overhaul of some other form of consumer protection? I mean, is a general convergent type of consumer protection legislation the one that we should be aiming for? Any thoughts, any views?
If I may start, I think that already what Michael was also mentioning, that the UCPD is an instrument that is cross-sectoral. So in principle, it should cover a lot of the practices that perhaps have been intended in a way also to be relevant for the AI Act. One difference that I immediately see is this idea of, for the UCPD is very clear. The test needs to be, are you manipulated into doing a transaction or undertaking a transaction that you otherwise would not have taken if the unfair commercial practice were not there. And then if we look at this Article 5 of the AI Act, I'm having the problem understanding whether also this would cover the economical effects of maybe an AI system, because right now, the way in which it is phrased, it has to deal with this causal link towards, or likely causal link towards physical or psychological harm. So what exactly are we looking at, especially if I look at the question as well with the Chucky-inspired doll example and the YouTube algorithm? What exactly is the test? Is the test that you have the AI system deployed by YouTube, and then you go and you get radicalized, and then you go in the streets, and then you're going to, put yourself at risk or commit a crime? Like, is that what we're looking at? Because that would be a very far-fetched, I think, type of test to interpret in practice. But please correct me, Ronald, if you have a different understanding.
No, so the consumer protection is not really my thing, but in terms, I think so. I don't know if the consumer protection regulation is adequate to deal with, let's say, modern manipulation practices. 2 years ago or something, a former student and I wrote a paper about Google duplex system. So what is changing is the the way bots, however defined, can sort of bring in more natural stuff like us and as in speech, and that seems to have a specific effect on individuals that you don't see with other forms of speech generation. So I think there is a potential risk of manipulation, which is way harder to sort of detect and get a grasp on. And I'm not sure if current consumer protection is adequate to deal with those kind of AI-based manipulation practices. But again, if that is the issue, then I would say let's see if we can build a regulatory framework to address manipulation specifically, rather than tie it to a technology.
Right, thank you, Ronald.
Can I say quickly one thing on that? Just sorry, super quickly, which is just
sure.
At that point on the YouTube point, the thing I've just put in the chat. Recital 16 has this really interesting section where it says intention in those manipulation provisions may not be presumed if the distortion of behavior results from factors external to the AI system, which are outside the control of the provider or user. So it says, actually, if YouTube says, these are just because of the recommendations of the user-generated content, let's not forget, in the e-commerce directive, YouTube is just meant to be like this chilled, neutral, technical, passive thing. Like, this is not, they're going to say it's not in our control. And so, like, socio-technical systems, like Ronald said, the little elves in the billboards, or APIs that go to real people behind screens, these things are weirdly out of scope, and that doesn't quite make sense. I really enjoyed Ronald's intervention on that area, and I think we see that again with the socio-technical systems, algorithms, and stuff.
Right, thanks, Michael. Thank you. There is one question for Michael from Amos, and he's wondering whether or not, without prejudice to other users' obligations under union or national law in Article 29.2, would help to preserve national laws that are protective in nature vis-a-vis the regulation, that the regulation wouldn't kill national laws, in that draconian manner, as seems to be suggested in the slide. I'm just wondering whether you might be able to comment on that, Michael.
That's a great question. So that's sort of a very weak version of what some people call a gold plating provision that exists in many areas. And bizarrely, the scope of this is only within the high risk system. So it's only user obligations that are within Title III. So you're already using one of these systems in this sector. This doesn't exist outside of Title III. So you get this weird asymmetry where like there's some ability for users to go further or to have laws to obligate them to do certain things within that high risk stuff, but not outside. Because I think that the Commission is sort of imagining that there'd be no reason for anyone to want to put obligations on users that relate to things outside this annex, which has just sort of been drawn up according to the Commission's own desires. So it's really strange. One thing I'd caution is there are several CJU cases where even where there has been gold plating provisions, CJU has more or less ignored them and just trodden over them. So it's a good start if we were to put a general purpose one in the AI Act that would be like that, but it doesn't take us all the way because we can look at the history of internal market law and see that the CJU does not always adhere to those, and indeed has to set aside some of these provisions sometimes because the way that 114 works. 114 is designed, is justifiable if it lowers barriers to trade. So parts of a regulation adopted on 114 that don't end up removing barriers to trade, the CJU has previously sort of basically cauterized out of the regulations.
Right, thank you, Michael. I think in the 10 minutes that we've got left, I'll bunch up a couple of questions in terms of the themes. I think one of the themes is the concern about compliance with this regulation, that if this regulation gives rise to a lot of legal risk and uncertainty, can these be fixed now in the process towards the legislation? Or if not, what sort of compliance are we looking at? And whether, I think someone suggested whether it would be possible to boycott, this particular legislation. How onerous will this be? I think that there are people who are designing systems out here that are probably truly concerned. So this is the compliance question, which I hopefully Ronald and Michael might comment on it. And I'll ask Michael and Catalina to comment on the second lot of questions, which is on kind of convergence and coherence between the AI regulation and other regulations. So shall we take the compliance one first? And Ronald, would you like to comment on that?
Yeah, so a couple of things. I'm fairly pessimistic about sort of enforcement in the short term. Should this be enforced tomorrow, then it will be highly problematic for reasons that Michael already explained, and also the fact that much is hinging on certification, which is not there yet, etc., etc. But on the other hand, taking a longer term perspective, and I don't know if we can actually permit ourselves that time. But if we go back in data protection history, I mean, the GDPR is not that fundamentally different than the Data Protection Directive, and that was enacted in the mid-1990s. And nowadays, the GDPR has a different function than in the period before that. So maybe this is sort of the first shot across the bow to make people aware. We're going to monitor AI and pay attention. This may be simple stuff yet, but more is yet to follow, and we're going to enforce more strict. If I may, I think one of the important things in the AI Act, in my view, is the accountability mechanism that is being sort of introduced there, similarly as what we have in the GDPR. If you want to bring a system on the market of any sort of complexity, then make damn sure that you have the paperwork ready, and then if there is harm, then people can try to, using tort and what have you, to get that documentation on the table and then whip the makers around the ears or whatever, to try and improve stuff. So I think enforcement may take a long route through courts, not immediately with the AI Act in hand, but through other legal mechanisms, and then having the sort of the accountability provisions as obligations to provide paperwork.
Right.
Michael.
I think comparing it to data protection is interesting, but I think data protection is also, it was a sui generis regime, in the 70s, 80s, this is a sort of Frankenstein's monster of a product safety regime. You know, I think it believes it's a lot cleverer than it maybe is, and so perhaps I think a real big challenge we have is if we've really built it out of bits and pieces of product safety legislation, maybe the way we had to regulate AI needed a bit more creative thinking. We really do have to go back to the drawing board, and this is what I think relates to the question that Carolina asked in the chat. What is it beyond repair? Should we start again? Should we boycott it? It's tough. You boycott it. What signal are you sending out that you do or don't want regulation at all in this area? If you want to do something different, do you want to have it on a non-internal market basis? Because frankly, that might require treaty change. If you're really trying to do this, then you need a referendum in Ireland, and then when do you then where does it take you down that route? So I'm not really sure exactly. I think we can lower the horizontality of this quite a lot and say this is not the final shot across the bows, and maybe we should be a bit more cautious with let's experiment and get enforcement right and convergence right and so on. But we'll need to have systems that can bring those cases to courts a lot more, get that kind of clarity, and it's not always going to be through tort. I mean, look at migration systems and so on that are also in this. We can't expect people to in those situations to sort of have standing to bring torts against providers of systems and so on. It's very difficult. And so I think we should lower the ambitions of this and try to deal with its worst aspects and see where that gets us as that shot across the bows.
Right, thank you, Michael. I think that the final kind of bunch of questions I'll direct to both Catalina and Michael to comment, and that's the issue of kind of convergence amongst different sorts of standards for AI systems. Do you think that it should be internationally convergent or not? And whether this regulation should actually achieve, better coherence with other forms. I mean, the digital regulation package, for example, do you see coherence and what can be done better to achieve coherence?
I think from my perspective, I think before we can even speak about any kind of international harmonization, the internal coherence of European Union law, I think is a very important topic. And exactly, Iris, what you were mentioning, the DSA, so we heard also about the GDPR, we spoke about the UCPD, all of these different instruments. So we don't just have the Frankenstein's bits and pieces, but we also have the originals from which Frankenstein has been built. So, and they're all kind of dancing together, so we need to understand, okay, where does one start and where does the other one stop? So I think that is a question that is very unclear at the moment. And in the past, and I see the interactions between data protection and consumer protection have led to some sort of cannibalization in enforcement, where maybe one type of enforcement activity said, no, this is about data. We're not going to touch this. So it belongs to the other authority. So I think that is a very important discussion to be had. In a way, I am glad, like I said, that there aren't any new institutions that are supposed to deal with the enforcement here, because at least with so if we're going to consider AI systems as products, or at least some sort of a proxy to products, and then market surveillance authorities need to deal with this as well. There is somewhat of some cohesion still within this consumer protection dimension, but what do we do with the fundamental rights discussions that the AI Act raises, where other types of agencies are supposed to be tasked with the enforcement? So I think that first and foremost, we need this internal coherence where instruments need to have, I don't know how to achieve this in practice, maybe through some sort of, maybe guidelines would not be enough, because directives have had guidelines in terms of application in the past, but we need these instruments to be much more interconnected, to be much more interoperable, if you will, not to misuse this word, but I'm curious what Michael thinks as well.
Yeah, I agree with Catalina on all those points. Really, really well put. I won't try and repeat them or anything. I'll try and answer the AI standards international side of it. That's a really big legitimacy problem. When you look at standards bodies, they are built because they want coherence, they want similarity across. They want to fit with ISO, fit with NIST, fit with other organizations around the world. Here, we're saying, well, this is a standard that's built in a very particular way to complement a certain kind of quite weird regime. And let's get civil society to engage in making the standard. That's going to be incredibly difficult to begin with, and let alone what is said by Dave Lewis in the chat is a really good answer to the question. Sen and Sandler are going to say, actually, why don't we just reuse bits that are made from an international standard where there was no legitimacy in the creation of the standard? It was never being made with fundamental rights. No one was joining this from different groups of society thinking it would be the core of a European regulation. And the court is also struggling with this right now. So there's the case. James Scott, the recent case on judiciability of standards from about 2018, then the Frabo case before that. The court has really struggled to think about, like, what role should the CJU have in bringing preliminary references and dealing with them when they're about standards by a standards body that is itself designed to push these things out of the European regulatory arena because of the difficulties of that. So we're entering a world where the cure, like, is going to be rife with legitimacy issues if the cure is to make standards that specify and make things pretty unambiguous. And I don't know if we're really going to. Again, I think we may have started in the wrong place with this regulation, and I'm not sure there's a great way out from where we are. We can only mitigate the damage.
Right, thank you very much, Michael. I think we've had a very, very fruitful and lively discussion, and mostly critical as well. And we hope that this is a good point in time for many of these reflections to feed into the processes as the legislation is undergoing scrutiny and modification. So let me thank my panel today, Michael especially for anchoring the speech today and the introduction to the regulation, and Ronald and Catalina for being with us, for offering their very scintillating views on different aspects that they're concerned about, and of course Ruben as well, who's had to leave early today. So thank you very much to my panel, and thank you the audience for all your questions and for being engaged with us throughout this session. So it remains for me to say, I hope you have really enjoyed this, and we'll be having this on YouTube not long after this, in terms of the recorded broadcast that has taken place today. So thank you all, and have a very good evening.